Hello and welcome back to Reason News. Today we bring you a landmark constitutional court decision that will impact millions of South Africans at home and abroad. The Apex Court has ruled that it is unconstitutional to automatically strip South Africans of their citizenship when they acquire citizenship of another country. For nearly 3 decades, Section 61A of the South African Citizenship Act 88 of 1995 has stipulated that any South African who acquires another country's citizenship without first obtaining ministerial permission automatically loses their South African citizenship. This law affected thousands, possibly up to 2 million South Africans, many of whom were living and working abroad, often unaware they'd lost their citizenship until they tried to renew a passport or return home. The Democratic Alliance, supported by its DA Abroad branch, spearheaded a decade-long legal challenge against this provision. Their argument: the law violated the constitutional right to citizenship as well as related rights such as the right to vote, to enter and remain in South Africa, and to pursue any occupation. In a unanimous judgment, Justice Stephen Majid wrote that the right to citizenship is cherished and should not be lightly removed. The court found that automatically stripping citizenship without notice, warning, or any real decision process is a plain deprivation of a fundamental right. Here's a video from the SABC News.
Provision is constitutionally invalid. Section 6(2) of the Act cannot save the impugned provision from unconstitutionality. The court then reflects on international and foreign law surrounding citizenship. There are no specific provisions in international law on dual citizenship, and in accordance with the principle of state sovereignty, each state may make provision for this. In a world of increasing globalization and transnational mobility, permitting dual citizenship is the norm rather than the exception. Many countries expressly provide for a right to dual citizenship, and the constitutions of a number of countries provide that citizenship may be lost only through voluntary renunciation. This, by implication, excludes a loss of citizenship due to acquiring the citizenship of another country. International law generally acknowledges that it is in principle legitimate for a state to wish to protect the special relationship of solidarity, loyalty and good faith between it and its nationals, and the reciprocity of rights and duties which form the bedrock of the bond of nationality. But loyalty has undergone a fundamental change in light of the commonality of global issues, and the loyalty objection to dual citizenship today no longer holds up to the same extent. In sum, then, the court holds that the impugned provision is unconstitutional as it infringes the right to citizenship entrenched in Section 20 of the Constitution, and consequentially other constitutional rights, namely political rights, the right to enter and remain in South Africa, and the right to freedom of trade, occupation and profession. The impugned provision must therefore be struck down. Finally, the court notes that careful consideration was given in the Supreme Court of Appeal regarding the remedy that would grant the most effective relief. That court struck down the offending part of the impugned provision and ordered that the striking down be with immediate effect to take effect from the date of its enactment, which is 6 October 1995. Excuse me. The Supreme Court of Appeal cannot be faulted for the conclusion it reached based upon its unassailable reasoning. The Act came into effect on 6 October 1995 when the interim constitution was still in force. The impugned provision is unconstitutional in terms of the Constitution, but the same is true in respect of the interim constitution. The declaration of invalidity should therefore take effect from the date of the Act's promulgation on 6 October 1995. There is no need for a suspension order, and the department accepted throughout this litigation that in the event of a striking down of the impugned section, such suspension would be unnecessary. And then finally, the DA is entitled to its costs. What remains is for the court to acknowledge the helpful written submissions of the amicus curiae, Dr. Spadija, particularly with regard to international law. The court makes the following order. 1. The order of constitutional invalidity of the Supreme Court of Appeal is confirmed. 2. It is declared that Section 6(1)(a) of the South African Citizenship Act 88 of 1995 is inconsistent with the Constitution and is invalid from its promulgation on 6 October 1995. 3. It is further declared that those citizens who lost their citizenship by operation of Section 6(1)(a) of the South African Citizenship Act 88 of 1995 are deemed not to have lost their citizenship. And 4, the respondents are ordered to pay the applicants' costs in this court, including the costs of 2 counsel were so employed. I hand on the judgment.
Loss of citizenship has severe consequences. It entails being deemed to be a foreigner, where the law automatically terminates citizenship without any forewarning and even knowledge, simply on account of dual citizenship. That is plainly a deprivation of citizenship. The court declared Section 6(1)(a) invalid from its inception in October 1995. All affected people are now deemed not to have lost their citizenship. The Minister and Director General of Home Affairs were ordered to pay the costs of the application. This is a major victory for South Africans living abroad, estimated at nearly 2 million, who may have lost their citizenship unknowingly. It also affects those in South Africa who acquired a second nationality for work, family, or personal reasons. The ruling restores their rights and dignity as citizens. The DA called the ruling a victory for constitutional rights and a testament to the mandate given by voters to protect them from government overreach. Minister Leon Schreiber welcomed the judgment, saying it lays the foundation for restoring the dignity of all South Africans who lost their citizenship due to this unconstitutional provision. He confirmed that South African law allows for dual citizenship and there is no justification for deprivation of birthright in this manner. The Department of Home Affairs is moving quickly to comply. Work has already begun on an online portal where affected individuals can confirm their citizenship reinstatement from anywhere around the world. The system is expected to go live next month and the public will be notified. Could Parliament try to amend the law again? Legal experts say any new law would have to pass constitutional muster. Advocate Paul Hoffman explains that Parliament would need to find a legitimate purpose for any restriction on citizenship, and the Constitutional Court's reasoning leaves little room for such a law to survive review. Any law inconsistent with the Constitution is invalid, and the Court found no good purpose in automatic deprivation of citizenship. Section 6(1)(a) was enacted in 1995 under South Africa's interim constitution and remained in force under the current constitution. The law required anyone seeking another citizenship to first apply for a retention of citizenship letter from the Minister of Home Affairs. Failure to do so meant automatic loss of South African citizenship. However, the Constitutional Court found this approach irrational, arbitrary, and lacking any clear criteria for the minister's discretion. The court said there was no rational connection between acquiring a second citizenship and losing South African citizenship, especially in a world of increasing cross-border migration. Citizenship is more than just a passport. It is the right to participate in your country's political life, to vote, to work, to live, and return home, and to belong. The court emphasized that stripping citizenship undermines all these rights, making someone a foreigner in their own country. Many countries allow dual or multiple citizenships, recognizing the realities of global mobility. The court's ruling brings South Africa in line with international norms, affirming that citizenship should not be lost automatically or arbitrarily. For South Africans abroad, this ruling means restored rights and peace of mind. For those at home, it means the freedom to pursue opportunities overseas without fear of losing their identity. For government, it means a renewed commitment to upholding constitutional rights and modernizing the citizenship process. The Constitutional Court has struck down a decades-old law and that strips South Africans of their citizenships for acquiring another nationality, declaring it unconstitutional and restoring citizenship to all those affected since 1995. The Department of Home Affairs is working to ensure compliance and to help people reclaim their status as South Africans. This judgment is a milestone for constitutional rights and the dignity of every citizen. Until next time, stay informed, stay updated, and stay curious.